be served on each of these individuals. And thereupon, if the deputy commissioner is of the view that the petitioners are illegally occupying land which are falling within the tribal belt identified, then the proper procedure prescribed in the law is to be undertaken for carrying out the process of eviction if permitted under law. While doing so, while conducting the hearing, the Deputy Commissioner Morigaon will adhere to the directions passed by the apex court by the order dated so and so in SLA number so and so. Stopped by the said order, the apex court directed that the deputy commissioners must examine the claim of each occupant on case-to-case basis, and thereafter, if the order is found to be adverse to the petitioners, then a reasonable time must be given to the occupants to take recourse to appropriate remedy as permissible under the law. Accordingly, the deputy commissioner will now proceed to hear each and every individual on the basis of the documents and the replies filed by the petitioners and conduct the necessary hearing on a case-to-case basis. Stop. Since the petitioners are also represented through this court, individual notices for the hearing need not be issued. The petitioners or their representatives will appear before the deputy commissioner on
my lord, 10 days from 15 days from today.
1 week from today, my lord. 1 week from today,
on 5th
my lord.
of February.
My lord.
And thereafter, the deputy commissioner will proceed to hear each and every matter and thereafter pass speaking orders, if need be, on individual basis.
It is a time frame, my lord.
The
30 days.
petitioners, the documents submitted by the petitioners, as also the petitioners, would be given opportunity of being heard adequately, and the entire hearing should be completed within a period of 30 days. From
Can
5th
it be
of
45 days, my
No,
lord?
30 days, my lord.
There are
I'm
many
also-
petitioners, my lord.
Only the petitioner here only, no?
sorry, it's not 5th of February, it will be 9th of February. Within 30 days from 9th of February, and pass effective orders. If in the event the deputy commissioner is of the view that the hearing cannot be completed within the time frame specified by this court, then same must be completed within another period of extended 15 days.
Until then, exercise is carried out.
Thereafter, stop. Till such a hearing is conducted, the revenue authorities will not proceed to evict the petitioners from the said land. In terms of the notices dated so and so. Copy of the comments received by the respondents, which are placed before the court, is kept in the case report.
Yes, madam.
The writ petition accordingly stands disposed of in terms of the above.
Deeply obliged, deeply opposed.
The item number 3 and 4, Lordship, we need more time to file our affidavit, Lordship. We need more time to file our affidavit. Lordship,
3 and
we
4.
allow 4 weeks time, Lordship.
Item 3 and 4. Yes,
My lord, the date may be fixed, my lord. The petitioner is suffering, lord.
Mr. A.M.S. Mazumdar for the petitioner, M.S. G. Hazarika appears for respondent,
That's one number 1 and 2, Lordship, for Revenue Department.
1 and 2.
Lordship.
M.S. Mary appears for 3, 4, and 5. Respondents are permitted 3 weeks further time to file their affidavit. The respondents will endeavor to file their affidavit within the time extended by the court. Let the matter be listed again.
After 4 weeks, Lordship.
Hmm?
After 4 weeks.
On 6th of March,
Deeply applied.
the petitioners are also given liberty to file their reply affidavit to any such affidavits that may be filed with the petitioners.
Problem.
Respondents, sorry.
Lordship, that acquisition of petitioner's land without issuing any formal notification under the National Highway Act. And now on last occasion, they have contended that it is a government land.
Hmm?
Now the last occasion, they have furnished instruction that it is a government land. So let them file concrete affidavit, how my land fall on as a government land.
Sir, his land is occupied by the Doug number 808.
No.
And
My-
that is, my lord, sorry, his land is, my lord, 777 and 789. And that has not been taken for acquiring also, or neither any eviction took place. Eviction only with regard to, my lord, 808, my lord. That he is a small part, he is occupying, my lord.
We bring it on record.
My lord,
Yes, Lordship. Let them.
It's a matter
bring it
of
to
fact, so
record.
bring it on record.
my lord.
I have annexed the sketch map also, how my land has been acquired with photograph.
P.P. Dotto appears for the petitioner, Mr. N. Das, Governor Advocate, appears for respondent,
My lord, 345.
3, 4, 5. MS so-and-so appears for respondent 1,
1, 6, 7, and 8.
1, 6,
7 and 8.
7, and 8.
File our affidavit.
MSPR Monto for respondent 2. Yes,
Want to file our affidavit. Highway. Also want to file our affidavit.
you want to file your affidavit. The respondents are permitted to file their counter affidavit within 2 weeks from today. According to the respondents, the land occupied by the writ petitioner is not has not been acquired
Yes.
by the National Highway for the purposes of National Highway. Construction of National Highway,
Highway number 17,
highway number 17,
17.
National Highway 17. Under such circumstances, since there are factual issues to be decided, that the affidavits be filed as expeditiously directed by this court.
May I pay for that?
Um,
Do it, sir.
20 February.
Obliged.
Yes, in the last one. Last, the orders is. Who is for the health department?
My lord,
Any affidavits filed?
in this case, my lord, I have submitted a list of judgments, ma'am. Also served them, my lord, and also sent by,
Any affidavits filed by the respondents? They were supposed to file an affidavit.
they jointly file in item 10, my lord. There is a series, ma'am.
Who is the health department? Health departments. Please call for the health department standing counsel. We will call it up after a while.
Lordship has heard this matter. Lordship has heard this matter. The last part is that, my lord, they went to the Supreme Court, my lord. Supreme Court dismissed their application.
Can you refresh our memory?
Yes, yes, yes. My lord, we have filed this application under section 11, my lord. So this is continuance of arbitration proceedings, my lord. And we have, for dispute number 6 and 7, we had invoked the arbitration clause, and lordship may come to page 272, my lord. So that's, my lord, we have said that earlier arbitrator should be appointed as this arbitrator. So they have filed objection, detailed objection also. But, and we have shown the judgment, my lord, that it's ultimately the arbitral tribunal to decide clause 55.2 whether that is in respect of deciding the issue, my lord. Lordship may see page 125, my lord. That 55.2, my lord. That is the in dispute, my lord. That 55.2, my lord, lordship.
This is where the objection is that there is no arbitration clause insofar as that part of the dispute.
Yes, yes, 20% that cannot be agitated. That's the case that Justice Honorable Justice Suman Sham has passed an order, and they went to Supreme Court, which they have suppressed this from this honorable court. So lordship,
Where is that order?
that order is, my lord, at page, my lord, 266. That is Honorable Justice Suman Sham order. Against this order, they went to Honorable Supreme Court, and Supreme Court dismissed. But we have placed the Supreme Court order also, my lord.
Where is that order of the apex court?
My lord. Yes, I have given me that. 12/7/2024. This order was, my lord, because we are not been issued notice, my lord, so we are not aware, we got from internet that their petition, they has been dismissed, my lord. Which they have suppressed, they have filed detailed objection, my lord, annexing all the volumes of documents, orders of the court, but they didn't suppress this order from this honorable court, my lord. Ah.
arbitration এখন না। Where is that order passed by the apex court in this Bangalore Metro Rail Corporation?
Bangalore Metro Rail, my lord,
Have you taken a copy of that?
that is not with us, my lord.
Get a copy.
Bangalore Metro.
They order to some. It was her. I don't want to see it. So I don't think very good.
There is another judgment, my lord, latest judgment, I have not placed it, my lord, on 17/12/2025, my lord. There also, my lord, it is the arbitral tribunal which has to decide the issue.
Give it to us.
Yes, I am giving. Latest, my lord. Here, my lord, my lord, para 18 and 21, my lord. Para 18, internal page 18, my lord.
Para 18.
Yes, my lord. May I read, my lord?
Yes.
Following this court's mandate in the above decision, this court in Managing Director of Bihar State Food and Civil Supply Corporation Limited and Sanjay Kumar explaining the contemporary legal position of the referral court emphasizes that I've placed it that this order earlier, my lord. The curtains have fallen. Courts exercising jurisdiction under section 11(6) and section 8 must follow the mandate of subsection 6A as interpreted and mandated by the decisions of the court, and that scrutiny must be confined to examination of the existence of the arbitration agreement. Then 21, my lord.
Hmm.
Conclusion. Having considered the matter in detail, we are of the opinion that the High Court has not committed any error in constituting the arbitral tribunal in exercise of its power under section 11(6), 11(6A) of the Act 1996. The arbitral tribunal will consider all questions, including preliminary objections relating to maintainability of the arbitration on their own merit. So here is also dispute that said 20%, they cover that will not. And in fact, my lord, Honorable Justice Suman Sham had dealt with that point, my lord, at para, lordship may see. Suman Sham, I think. Seven. No, 266, my lord. Lordship may come to para page 268, my lord. Honorable Justice Suman Sham's order. Para 4, my lord, page 268. The learned CGC appearing for the respondents has primarily resisted the claim of the petitioner company by stating that in view of the amount involved in the claim, it was not arbitrable dispute on the amount exceeded 20% of contract value. Then para 5, the said assertion of the learned counsel of the respondent has however been strongly refuted by the learned counsel for the petitioner by relying on a decision of this court rendered in the case of GSR Ventures Private Limited and others versus Union of India and others reported in so-and-so. Mr. So-and-so learned counsel for the petitioner submits that the value of the claim raised by the petitioner can be viewed more than the one single, and when two views are possible, such a dispute pertaining to question of jurisdiction of arbitrary tribunal must be raised before the tribunal itself. By referring to the clause 64 of GCC, Mr. Sayavala has further argued that this is a case where a three-member arbitral tribunal is required to be constituted so as to enter into reference in respect of the dispute, and since the respondents have failed to respond to the demand made by the petitioner for appointment of arbitrator, the second arbitrator be also appointed by the court from the existing panel so as to facilitate the constitution of the three-member arbitrary tribunal. Then clause has been discussed, my lord, and finally, your lordship may see the next page, my lord. Para 9, my lord, page 270. As per clause 64(3)(a)(2) of the CGSE, the dispute is required to be adjudicated by a three-member arbitrary tribunal to be headed by a presiding arbitrator. I find from the record that the petitioner has suggested the names of Justice E. Padmanabhan, former judge of Madras High Court, to act as an arbitrator nominated by the contractor. Mr. Gupta learned CGSE has produced a copy of the communication dated 28/9/2021 issued by the Deputy Director, Chief Engineer, so and so, addressed to the petitioner company forwarding the names of three nominees of NF Railway for appointment as arbitrator on behalf of NF Railway. Mr. Gupta submits that any one of them may be appointed as an arbitrator as nominee of the railways after going through the communication dated 28/9/2021 and based on the submission made by Mr. Gupta, Shri H.K. Gogoi, ex-General Manager NF Railway, here by appointed as arbitrator on being nominated by NF Railway. Both the arbitrators would now take necessary steps for appointment of umpire or presiding officer in accordance with the mandate of Act 1996, so as to constitute the three-member arbitrary tribunal. So there Deepak Gupta, Madam Honorable Just former judge of Delhi, my lord, High Court, and Supreme Court, okay? Supreme Court, my lord, and E. Padmanabhan and H.K. Gogoi from the railway has been appointed as arbitrator. That is in respect of dispute number 5, my lord. And now the dispute number 6 and 7, lordship has to appoint the arbitrator as per the.
Where are these disputes numbered?
Yes, lordship may see page 250, 264, my lord. Their own document. They have given the list of disputes and the appointment of arbitrator, my lord. Dispute number 2, lordship may see on the down below, my lord. It is to mention here that contractor has already submitted 5 disputes for the same contract, details which are as follows. Dispute number 2, Madam Honorable Justice Amitabh Roy, my lord. Dispute number 3, Honorable Justice Amitabh Roy again, my lord. And dispute number 4, Honorable Justice Amitabh Roy. And dispute number 5, my lord, Devender Gupta, E. Padmanabhan, and H.K. Gogoi, my lord. So, but Devender Gupta is no longer there, my lord. Instead of him, my lord, Deepak Gupta has been appointed.
Now, where is dispute number 6?
6, my lord, we have dispute number 6, my lord, page 236. (236) and dispute number 7, my lord, 246. This is claim in respect of additional costs incurred during the extended period of the contract from 1/4/2019 to 31/7/2020 on account of delays, reasons and reasons not attributable to the contractor. And dispute number 7, my lord, 246. Claim respect of additional cost, but is it time period, my lord? 1/8/20 to 7/10/21.
240? 240?
246, my lord. Then they have responded, my lord, that is page 263, my lord. Both the claim, my lord, they have responded by their reply, my lord, 13th May 2024 at page 263. Their basic claim is that, my lord, is more than 20%.
Dispute 6 is at page 236.
My lord, claim 6 to 236, my lord,
Hmm.
and 246 is the claim number 7. Lordship may come to page 265, their reply, my lord. This starts from page 263. Then page 263 is the relevant portion where the Supreme Court has interfered, my lord.
260?
263, my lord.
Hmm. It starts from, reply starts from 263, my lord. Hmm.
Yes. In middle portion, madam, clause 55.2, Lordship got it. 265, clause 55.2.
Yes.
Yes, clause 55.2 of the contract provides that the provision of 63 and 64 to the general conditions of contract will be applicable only for settlement of claims or disputes between the parties for values less than or equal to 20% of the value of the contract. And when the claims disputes are value of more than 20% of the value of the contract, provisions of clause 63 and 64 and other relevant clauses of the general condition of contract will not be applicable, and arbitration will not be a remedy for settlement of such dispute. As per the above para, total value of all the claims or disputes cannot be more than 20% of the contract value, and thus request for demand of arbitration is not maintainable, as there is no question of appointment of any arbitrator as requested by the contractor wide letter under reference. Now, this was challenged before the Honorable Supreme Court, and Honorable Supreme Court is specifically stated that, my lord, if your lordship, they take the Supreme Court order, my lord, Honorable Supreme Court's order, we are not inclined to interfere with the impugned judgment. However, if claims filed are beyond the stipulation in clause 55.2 of the contract agreement, it will be open to the petitioners to raise the contention of non-arbitrability before the arbitral tribunal. We clarify that we have not made any comment on the merits
You
of
are
the
reading from which order?
but it's Supreme Court order, madam. Honorable Supreme Court's order. Here they said as per
That is on 21st of August.
the 21st of 12th July 2024.
Yeah.
That I've given, again, I've given the order, madam. Supreme Court's.
No, we have one order here where Justice Amitav Roy was
No,
appointed.
no,
as-
not that. I'm reading, madam, the newspaper I've given, my lord. SLP order. Because after, madam, this, earlier also, my lord, Honorable Justice Suman Sham has passed an order referring to clause 55.2, and Supreme Court again gone into that, my lord.
No, I know. So against this order, the order of August 21 was passed. Against the order at page 267.
No, my lord, no, my lord.
Huh?
Yes, against the 266, that is Honorable Justice Suman Sham's
Ah.
order. Against that, my lord, Supreme Court has passed this order on 12/7/2024.
12-7.
12/7.
That order we don't know.
I, just I've given, my lord.
We have August 21st and February 17 order.
No, my lord. Just 2-page order, my lord.
You give us one more copy?
Yeah, one more copy, my lord. No, that is not, that is separately, my lord, separate news sheet, my lord.
1 minute. 12-7, yes.
Yes, yes.
Yes. This 12-7 is the order passed against
Against the Honorable Justice Suman Sham, my lord. That is
267.
at page 266.
Not this August 21st.
No.
August 21st is against which order?
August 21st, my lord. That is old order, my lord. That is earlier orders, my lord.
Well, there is no challenge to that order, my lord.
Hmm?
There is no challenge to that order, my lord. But my lord, they have approached because this honorable court has kept the issue pending, my lord, till decision of the core matter, my lord. So against that order, they approached the honorable Supreme Court, and Supreme Court said that pendency of that core issue will not be.
Come to page number 267.
My lord,
Against this order, did you file an SLP?
yes,
Where is that SLP?
my lord.
Read it out. What is the date of the order?
Date of the order is, my lord, 29/1 sorry, 12/7/2024. my lord.
12/7.
My lord.
They have not produced this order. We have produced this order. They should have. My lord, may I read the order, my lord?
1 minute. Yes.
Yes.
My lord, on the top lordship may see arising out of impugned final judgment and order dated 29/1/2024 in arbitration petition 25/2022 passed by Guwahati High Court. Then 12/7/2024. Now, we are not inclined to interfere with the judgment. However, if claims filed are beyond the stipulation in clause 55.2 of the contract agreement, it will be open to the petitioners to raise the contention of non-arbitrability before the arbitral tribunal. We clarify that we have not made any comment on the merits of the aforesaid submission. Recording the aforesaid, the special leave petition is dismissed. So they are very well aware of the fact that, my lord, that they raised this clause 55.2, which is they went to the Supreme Court, my lord. They have suppressed this fact before this court, from this court, my lord. They have filed 400 pages, volumes of document. Nothing prevented them to submit, but why they have not placed? Because we are not issued a notice, my lord. So they thought that we will not know about this order passed by the Honorable Supreme Court. Then, my lord, we issued two notices, my lord, for appointment of arbitrator. That is, one is at page 272 and other is at page, my lord,
All right.
272.
Yes, Mr. Goswami, anything further?
Madam, I'd like to read this judgment, my lord, once again by this honorable court. Dated 29/1/2024, my lord. At para 5, my lord, at page 268, my lord.
What is it? Where is the judgment?
At page 268 of the, my lord, arbitration petition, my lord.
268.
My lord. My lord. My lord, para times 268. Like to read of para 4 and 5, my lord.
268.
My lord.
Yes.
Para 4, my lord.
Uh,
My lord, the learned CGC appearing for the respondent has primarily raised the claim of the petitioner company by stating that in view of the amount involved in the claim, it was not an arbitrable dispute as the amount exceeded 20% of the contract value. The said assertion of the learned counsel for the respondent has, however, been strongly refuted by the learned counsel for the petitioner by relying a decision of this court rendered in case of GSR Ventures Private Limited versus so reported in so. Mr. Sahel and learned senior counsel for petitioner submits that value of the claim raised by the petitioner can be viewed from more than one angle. And when two views are possible, such dispute pertaining to question of jurisdiction. My lord, this is my lord, pertaining of jurisdiction, my lord, of arbitral tribunal must be raised before the tribunal. There is no dispute, my lord. Regarding my lord jurisdiction, it has to be raised before the honorable, before the arbitrator only. My lord, now, my lord, I'll come to my lord the order passed by the honorable Supreme Court against this order, my lord, where my lord, our petition was dismissed, my lord. The first, my lord, first para, my lord, we are not inclined to interfere with the judgment. However, if the claim filed are beyond stipulation, in clause 55 onto our corporate, it will be open to the petitioner, my lord, to raise the contention of non-arbitrability. My lord, here, two things, my lord. In the first order, whether there is jurisdiction, number one. And second, my lord, whether it is beyond the stipulation of 55.25. Here, Lordship has put a question, my lord. This case is different because, my lord, we have not brought it to before this honorable court. Lordship has, my lord, directed, my lord, that those arbitration petitions which were referred to the arbitrator, whether you have brought it to by way of an affidavit, we have not, my lord, then, my lord, we have filed this additional affidavit, my lord, whereby, my lord, we have shown that it is beyond the, my lord, stipulation. We have shown it, my lord. Limit has been crossed, my lord. My lord, we have not.
that has been decided by the
My-
tribunal.
my lord,
Our-
we
our
have-
decision.
my lord, the second, my lord, my lord, I would point out, my lord, once, my lord, it is, Lordship has found that it is beyond the, already crossed the limit, my lord. My lord, it is crossed the limit, my lord.
See, the question is whether a referral court is required to decide this issue or it can be left to be decided by the arbitral tribunal. There are several judgments where it says that if this is a question, let it be before
My lord,
the
my
arbitral
lord,
tribunal to decide.
I'll place one judgment, my lord. SPA. My lord, already it is there, my lord. 2024 SCC online, SC 1754, my lord. SBA General Insurance. My last page, my lord. Conclusion, F, my lord. Last page, my lord.
Yes.
Para 135. The existence of the arbitration agreement as contained in clause 13 of the insurance policy is not disputed by the appellant. The dispute raised by the claimant being one of the quantum and not of the liability primarily falls within the scope of arbitration agreement. This dispute regarding accord and satisfaction as raised by the appellant does not pertain to existence of arbitration agreement and can be adjudicated. So, my lord, if it is regarding existence of arbitration agreement, it can be raised before, my lord, before the, my lord, this honorable court, my lord. So, my lord, I am raising this specific issue, whether, my lord, after crossing that limit of 20%, whether this arbitration agreement exists.
That's a wrong question you have framed.
My lord, in my
Therefore,
lord,
we can reject it outright or you may consider it reframing. If the existence of an arbitration has to be disputed, when you say that this is not an arbitration agreement, let us say in a particular case,
Right.
there was a contract between X and the petitioner. there was an arbitration agreement.
Yes, ma'am.
Subsequently, that acts came to be taken over by, let us say, the railways. Now, the railway may, in a given case, raise this question that this arbitration agreement was not executed with us, whether it exists with the railways. Just to give you an example, here is a case, according to you, there is an arbitration agreement, but it is applicable only to 20% of the dispute. Question is whether it is 20% per se or 20% of the total. According to the petitioner, it is 20% of the disputes raised. They have separately urged these disputes and have attempted to show that they're all within 20%, which according to you is 20% must be in the total of all the disputes. So therefore, if it is 20%, then there's no arbitration as per the agreement. But if you question the very existence of the arbitration, then your objection falls through. You're raising this 20% on what basis? On the basis of an agreement, which you are now questioning that this arbitration agreement does not exist.
Other than existence, my lord, we cannot question anything. madam.
Huh?
Other than existence of arbitration agreement, we cannot question
No,
anything.
no, you cannot question the arbitration agreement
We cannot
because
raise any dispute.
your primary objection is 20%.
Right.
This 20% you have culled out from where? From the agreement. Clause 55. Yet you say that no, it does not exist because it has gone beyond 20%. So this beyond 20% or not would be a question of accord and satisfaction.
My lord, I submit one.
This will have to be decided by the, left to be decided by the arbitrator.
My lord, but my lord, we have, my lord, the problem is with us, my lord. If, my lord, this is allowed, my lord.
Hmm?
They have already brought, my lord, 7 disputes, my lord. They can, my lord,
No, no, no.
bring another 7 disputes, my
Mr.
lord.
Goswami, you can
And my lord-
raise every objection with regard to the existence of arbitration. But it cannot be on the ground that an arbitration agreement will fail the moment it crosses 20%. From where do you find that clause?
My lord,
Clause merely says that arbitration is permissible when the disputes are within 20%. It does not specify whether it is the totality of the disputes or disputes raised individually. These are issues to be decided on merit.
my lord, I would like to give one small example, my lord, here, my lord. If an agreement is made between 2 parties regarding sale of a plot of land, my lord, that agreement is for that specific plot of land, my lord. He cannot come and say, look, since you
That's
signed
right.
an agreement.
So therefore,
You have to sell to the other plan also.
no. Therefore, the objection raised in respect of that agreement
Right.
is prima facie that agreement itself. You will have to first accept that there is an agreement. But this agreement is only with regard to this plot of land, not to that other plot of land. Can you raise an objection to say that there is no agreement?
My lord, here also, my lord, my respectful submission is that, my lord, we have, my lord, 6, my lord, 5, my lord, dispute has been already sent, my lord. It is by your lordship, my lord. Once, my lord, 5 dispute has been sent, my lord. And my lord, there is a, my lord, I have also, my lord.
We have,
two
if there is
judgments, my
anything
lord.
more you want to argue, you
My
can
lord,
do it,
my
but
lord, 2 judgments I would like to place, my lord, 2 judgments, my lord, already.
uh,
That is there, my lord.
you have placed 4 judgments here. One is that SBI
My,
Insurance, then Oriental,
my lord.
then United Insurance Company,
Hmm.
and Beaver Infra.
And my lord, one more is my lord, Oriental Insurance Company Limited, purchase of my lord, yes, my lord. And United India, my lord, these 2, my lord.
Huh.
I'm relying on these 2, my lord.
These judgments are earlier judgments. They are subsequent later judgments. Later judgments, amongst others, you should, even SBI General Insurance, the way you are trying to interpret perhaps may not be available. There are later judgments placed by the petitioners. Have you given them a list?
Yeah, give it.
My lord,
There is a civil petition, then civil appeal.
My lord,
Then this Bihar state. Then Aslam Ismail, Goki Technologies.
Lastly, my lord, Andhra Pradesh.
Hmm?
Lastly, Andhra Pradesh, my lord. Last judgment.
my lord, my
Andhra
specific
Pradesh.
one, my lord.
Power corporation, power generation. This we just searching, my lord, we came to know this judgment.
My lord,
Have you placed a copy
Yes, I just, yes,
just now?
yes, yes,
Andhra Pradesh.
yes.
my lord, whose judgment, my lord? Here, my lord, in this judgment, my lord. My lord, three judgments, my lord. 2018-17 SCC 607 United India Insurance Company Limited versus Hyundai Engineering, my lord. This is specifically on, my lord, conditional arbitration agreement, my lord. This is specifically on conditional special.
Paragraph?
My lord, paragraph 12, my lord.
You're referring to the Hyundai.
Yes, my lord. Oriental versus Hyundai. Oriental versus Hyundai.
Yes.
My lord, paragraph 12. From the line of authorities, it is clear that the arbitration clause has to be interpreted strictly.
Hmm.
This subject clause 7, which is perimeter of clause 13 of the policy considered by three judgments in Oriental Insurance Company Limited, it is a conditional expression of intent. Such an arbitration clause will get activated or kindled only if dispute between the parties is limited to the quantum to be paid under the policy. The liability should be unequivocally admitted by the insurer. That is the precondition and sine qua non for triggering the arbitration clause. To put it differently, an arbitration clause would be enlivened on invigorated only if the insurer admits or accepts its liability under or in respect of the policy concerned. That has been expressly predicated in the opening part of the clause 7, as well as the second paragraph of the same clause. In the opening para, it is stated that liability being otherwise admitted, this reinforced and restated in the second paragraph in the following words. It is clearly agreed and understood that no difference or dispute shall be referable or to arbitration, as herein before, provided if the company has disputed and not accepted liability under or in respect of this policy. Thus understood, there can be no arbitration in cases where the insurance company dispute or does not accept the liability under or in respect of the policy. So, my lord, we are disputing, my lord.
Then you come to the next paragraph.
Well, the core issue is whether the communication sent on 21/4/2012 falls in the accepted category of repudiation and denial of liability in toto or has the effect of acceptance of liability by the insurer under in respect of the policy and limited to the disputation of quantum. The High Court has made no effort to examine this aspect at all. It only reproduces clause 7 of the policy and in reference to the dictum in the Duro Felgura held that no other inquiry can be made by the court in that regard. This misreading of the said decision and the amended provision and the particular misapplication of the three judges bench decision of this court in Welcome Insurance Company Limited and Oriental Insurance Company Limited. Paragraph 14, my lord. Reverting to the communication dated 21/4/2011, we have no hesitation to take the view that the appellants completely denied their liability and repudiation dated the claim of the JV, respondents 1 and 2, for the reason mentioned in the communication. These reasons are specific. No plea was raised by the respondent that the policy or the said clause 7 was void. The applicants repudiated the claim of the JV and denied their liability in toto under or in respect of subject policy. It was not a plea to dispute the quantum to be said under the policy, which alone would be referred to arbitration in terms of clause 7. Thus, the plea taken by the appellant appellant is of denial of its liability to indemnify the loss as claimed by the JV, which falls in the accepted category, thereby taking the arbitration clause ineffective and incapable of being enforced if not non-existent. It
This
is
is
not,
exactly the dispute here.
my lord,
This is not a case of non-existence of the argument, agreement.
my lord, my lord, I
This
will
is a
read the
case
later
where
part
you
also,
are-
my lord. I would like to read the
This
later
is a
part also.
case where you're questioning the interpretation of a clause as specified in the agreement. Your interpretation is 20% of each of the disputes. Once you have, 20% of the disputes in total. Once it has crossed 20%, then you can't go for arbitration. The interpretation of the petitioners on the other end is, no, it is 20% per claim. So therefore, it is not a case where you deny the existence of the arbitration clause. The purpose of the application before this court, the jurisdiction of this court stems from the fact that there is an arbitration clause, arbitration agreement between the parties. You do not deny the fact that there is an arbitration agreement. You dispute the particular clause on the ground that according to your understanding, it has crossed the limit of 20%. Therefore, no arbitration. So how can you say that this is a case of denial of liability or responsibility?
My lord,
It is a case of disputation of the quantum.
my lord, I'll read the later written today, my lord.
Hmm?
Whether, my lord, we have denied the liability, my lord. My lord, we'll read the letter, my lord, once again, my lord.
No, I don't think it is. We
My lord,
need to go
it
into
is-
those aspects
My lord,
considering the.
my lord, kindly see, my lord, at page 264, my lord. Page 264, my lord.
What is the status of the clause today? You must be having similar clauses in subsequent contracts.
Yes, my lord.
Is it similar or same?
My lord, my lord,
What happened to the pending arbitrations? Any awards?
yes, my lord, rejected, my lord.
They have raised the preliminary objection
Uh,
with regard to maintainability, same thing, my lord, but arbitrator has rejected it, my lord.
My lord, now we can, my lord.
Any appeals file?
My lord, yes.
No.
Yes, my lord.
Oh, yes, section 35, I think pending in some cases.
Well, we have filed, my lord. We have filed, my lord. But, my lord, thing is this, my lord, once we have to get in a stay order, my lord, we have to pay 50%, my lord. And lordship may look, my lord, 7 claims, my lord. How many, my lord, state exchequer will have to be spent, my lord?
You have entered into a contract with your eyes and ears open.
But, my lord, kindly say 264, my lord, whether, my lord, we have denied or not, my lord.
Yes.
My lord, last para, my lord, it is to mention here that the contractor has already submitted 5 disputes for the same contract. Details of which are given, my lord. 35 crore, Roman 2, 231 crore, Roman 3, 163 crore, Roman 4, my lord, 219 crore. And the contractor has further claimed an amount of 72 crores and 50 crore respectively in dispute 6 and 7. Thus, the total amount claim raised in so far is 768 crore, which is almost 77.8% of the long contracted price, and 54 of the revised contract value. Original contract value is 987 crore, revised contract value is 1403 crore. Now, my lord, they have clause, they have described the clause, my lord. As per the above para, total value of all claims disputes cannot be more than 20% of the contract value, and thus the request of the demander is not maintainable, and there is no question of my lord. We have.
Where is the denial of the arbitration agreement? This is again an interpretation of the section of the clause. You read clause 55.2.
My lord, I'll read this para, my lord. My lord, 55.2, my lord, this para. Clause 55.2 of the contract provides that the provision of clause 63 and 64 of general condition of contract will be applicable only settlement of claims, my lord. This is, my lord, my lord, highlighted, my lord, or disputes. So, my lord, it's singular, not singular, my lord, it's plural, my lord.
To that extent, you don't dispute the existence of the arbitration agreements.
My lord, yes, my lord, there is arbitration, but once they cross that limit, my lord, there is no
So
arbitration.
that, is it a denial of the agreement?
Yes, my lord.
Or is it a question of
No, my lord. It is
applicability
totally-
of the clause?
My lord, my.
How do you say that beyond 20% will amount to denial of the arbitration agreement itself? That is the question we are asking you. You are
My lord,
referring
my lord,
to
and-
even for the basic objection of denial.
my lord, then, my
You
lord,
are
lordship may
referring to
kindly
the clause.
next 4 line, my lord.
Huh.
As per the above, total value of all claims dispute cannot be more than 20% of the contract value, and thus the demand of the arbitration is not maintainable. My lord, kindly last line of the earlier prayer. Other relevant 20 uh, claims or dispute between the parties for value less than or equal to 20% of the value of the contract, and when claims of disputes, again, my lord, disputes
Hmm.
are value more than 20% of the value of the contract, provision of section 64 and other relevant clauses of general condition contract will not be applicable, and arbitration will not be remedy. There is no arbitration. It's
Well,
not a remedy. my lord.
My limited understanding of the English language is that there is no objection regarding the existence of the arbitration agreement.
My lord,
You are raising objections with
Mal-
reference to
My
arbitration.
lord, it is said that arbitration will not be remedy, my lord.
All right.
Then, my lord, if it is not remedy, my lord,
Heard
then
counsel
this
for
is.
parties.
My lord.
We'll dictate the order in court in the second half.
My lord.
Maybe around 2:33.
All right, then.
To second half. Yes.
Lordship, may it please your lordship. Present with this. The present.
What are you challenging here?
Your lordship, the present arises as from a sequence of coercive executive actions taken by the GST department.
What actions?
The petitioner's GST registration is being suspended. Our bank account is being illegally frozen.
By which order?
Uh, Order is not being served to us.
Huh?
Order is not being served to us for the attachment
Who's for
of
the
bank account.
department, GST department?
Message. Your lordship, there is no proper order served to us. And if you may, people 6, para 7 of the petition. The same we have issued a letter as an Annexure G.
Yes.
Also, just a notice was issued regarding suspension of GST. And we have responded for the same. The notice is attached as Annexure K,
Hmm.
case 86 of the petition. Now response is also attached as Annexure L, case 87 and 88. And in between this, after the response, we have received no updation regarding any process or anything else. Thereafter, search and seizure was concluded on 21st of May.
Hmm.
And thereafter, the goods fair seized inquiry was made. And on June 16th, one of a sudden, we were responding all the inquiries and everything which the department has laid before us. And on 16th of June, we received a message from our bank that our bank is being attached by the GST department. As per section 83,
Hmm.
they have attached the
GST.
bank
Planning
account.
Council? GST Council. Yes. Yes.
As per section 83, they have attached the bank account.
Hmm.
And Rule 159 says that a copy must be served to the taxpayer, which was not served to us at any period of time. Although we have asked and submitted various letters to issue the same, but nothing was there. Our we may say it was illegally attached because the section specifically says that the order must be issued for the attachment of bank account by the Commissioner of the Taxes. But in our case, the order was issued by the ACT, Assistant Commissioner of Taxes.
Where is that order?
The order was not served to us.
Then how do you know?
We know, sir, actually, we saw in the bank, they didn't provided us. And the third thing is that our stock was also seized during the search and seizure procedure. And the same was illegally kept on our premises without authority of law by the department. A copy of order was obtained and the same
What orders were passed after the search and seizure?
final execution.
What orders were passed?
The order was finally they have executed the inquiry and raised the demand of 17.7.
Where is that?
Uh, 31st of December.
You are not challenging this order?
We will challenge it on the later purpose. So we, at the present, we are here for the interim orders to release the stock and revoke the suspension of GST.
Without
bank.
challenging the order, how can this interim orders
The
be
order-
passed? There is already a final order passed. You're not putting it to
But-
challenge.
No, but nothing is parallelly.
Yes, yes, show us. What is that order? What goal है Manuzan? You खाया ऐसे नहीं ये उनको बोल हैं What is your goal ऐसे नहीं
First one is for the bank attachment which was issued by the ACT.
Where is that final order?
That is one.
They've already passed this order.
Yes.
So what remains in your petition?
No, it remains for the procedures, the illegal procedures they have concluded.
You challenge this order if you want to,
We will challenge, we will,
then you challenge it.
but we are here for the interim order, my lord.
Huh?
We are here for some interim order.
No,
because the
interim orders
business-
don't grow on
business-
trees. We have to
business is
give you
paralyzed from
interim
last-
orders on the basis of orders being challenged before the court. You are not challenging the final order.
No,
You are
but then
challenging the procedure prior to issuance of the final order.
No, sir, the final order is here for the revenue, about the tax amount. And we are not for the tax amount here. We are here for the procedures which were against the law.
Heard counsel for parties. This writ petition has been filed by the petitioner, putting a challenge to the
An interim order for revocation of GST suspension and bank attachment.
revocation of the suspension of the GST registration of the petitioner, comma, for revocation of the attachment of the bank account, of the petitioner,
Illegal seizure.
and for restraining the respondent authorities from adjudicating the demand in the ongoing proceedings, and further to return all documents, including inventories and materials seized unlawfully, and also to quash the proceedings under INS 01 issued on 21/5/2025 and 28/5/2025. Stock petitioner has also prayed for interim orders. The pleadings are exchanged, where the respondent department duly contested the case of the petitioner. Petitioner has also filed the rejoinder affidavit, reiterates its grounds. Stop. During the course of the hearing of the writ petitioner, he has placed before the court the provisional attachment order issued by the concerned authorities for attachment of the bank account maintained by the petitioner under the ICICI Bank, Beltola branch. Stop. Further, orders have been passed under section 74 and 74 capital A of the Assam Goods and Services Tax Act 2017, read with the corresponding sections of CGST Act 2017 and IGST Act 2017. Stop. The said order was passed on 31/12/2025. By the said order for the financial year 2021-2022, 2022-2023 and 2023-2024. The respondent authorities have passed the following orders under section 74. Also under section 74 capital A for the financial year 24-2025 and 2025-2026, the following orders were passed. Stop. Counsel for the petitioner submits that this order is not yet challenged before the court. However, by virtue of the petition filed before the court, he has questioned the procedure adopted by the respondent authorities in conducting the search and seizure, as also the process for attachment or freezing the bank account maintained by the writ petitioner. Yes, Mr. Chaudhary,
Yes, ma'am.
anything to submit?
No, Lordship, in the affidavit, we have stated
There appears to be a final order passed.
that knowledge, Lordship, I have not.
Council representing the GST department submits that they have filed a detailed affidavit of proposing the contentions raised by the petitioner. However, he does not have instructions as to the order stated to have been passed by the respondent authorities in respect of the proceedings maintained. Then, having heard counsel for parties and upon perusal the pleadings and report, this court is of the view that the writ petition was filed, putting a challenge to the process undertaken by the respondent for suspension of the GST registration, the attachment of the bank account, and raising any demands in terms of the proceedings which were undertaken, and also to return the documents and inventories, materials seized unlawfully according to the petitioner, and further to quash the proceedings under INS -01 issued on 21/5/2025. So according to the court, since the final order has already been passed and there are adequate appellate provisions prescribed under the statute, the question of the procedure, question of the legality of the procedure undertaken by the respondent authorities, which is assailed in the present writ petition, have lost its force in view of the final order being passed by the authorities in respect of these proceedings undertaken. So, as admitted by the counsel for the petitioner, there is no specific challenge to the impugned order passed, either in the present writ petition or in any other writ petition proceedings before this court. Under such circumstances, this court does not find any merit in the present writ petition to entertain the claims raised by the petitioner in view of the final order dated so and so passed
Your Lordship,
by the respondent authorities. Under such circumstances, the writ petition, being devoid of any merit, stands dismissed. No order is to cost.
Your Lordship,
The dismissal of the writ petition, however, will not curtail the right of the petitioner to assail the impugned order passed, assail the order passed by the respondent authorities pursuant to the summons issued by the order dated 31/12/2025. Yes,
but after the adjudication, the stock and bank freeze and suspension of GST must be revoked by the department, which they have not revoked.
you urge it before the authorities.
We
You are
have
not even
submitted,
putting a challenge to
but
this.
no response was there for, and that the same was challenged here, Your Lordship.
Same was,
The same was challenged here. The
how can
legal
you
procedure-
challenge this without putting a challenge to the
No,
final
we-
order?
We will challenge it.
And you challenge it
on-
when you
on-
want
on
to
the-
challenge
On the
it.
course of the decision.
Dismissed.
Lordship, my appearance, may
Mr. B. Chaudhary, or the respondent. Huh? Yes, Mr. Gogoi, any affidavits that we are required to file or something?
No, my lord. In fact, on last occasion, my lord, by today, he will place the judgments and all that to show. My lord. Otherwise, my lord, the issue, my lord, regarding the review, it has been dismissed, now it's lying before the division bench. On this point, my lord, by coordinate bench. So that is a position, my lord, as of date. And he will rely upon certain judgments of the Honorable Supreme Court. And but my lord, when this particular issue on the very facts, my lord, if it has been considered by coordinate bench, whether
Dismissed.
that I leave it, yes, my lord.
But my lord,
When the writ appeal that they have filed against the review order as well as the main writ petition, delay has been found on and it is yet to be numbered and admitted.
this has been fixed on. Everybody.
So let it come after the closure of the writ appeal.
But my lord, here's the my lord. Subsequently, the apex court, the first the judgment, my lord. But in that context, my lord, in this circumstance, my lord, the coordinate based judgment becomes the parent Korea, my lord.
That you urged before the division bench in an appeal filed by you only.
Yes.
You urged it before the division bench. Mr. Bodhavu?
Lordship, so far as my case is concerned, they have not filed the affidavit, Your Lordship. And in my case, Your Lordship, I have challenged both the office memorandums and executive instruction issued by the authority, Your
No,
Lordship.
but is it covered by the order of the coordinate bench?
In my humble submission, Your Lordship, it is not covered, but still, Your Lordship, I will go through it again, Your Lordship, and will come back to this honorable.
According to the petitioner, the coordinate bench had relied on pre-amended
Lords.
notification.
Lords.
Therefore, subsequent to amendment, it will not be applicable to the present set of facts. However, that order has been passed, review was filed, review was
Review was-
dismissed. Now they have filed an appeal.
Your Lordship may fix it, Your Lordship, next week, Your Lordship.
But
I will also.
Next week, I think, when is the appeal fixed?
26th of February.
Heard counsel for parties, then we'll release it from part heard.
my lord, the very dismissal order, my lord, that the petitioner was failed to challenge the legality, my lord. Subsequently, my lord,
Mr. Counsel, an order has been passed by coordinate bench. Either the order is judicial discipline binds us to follow an order if it is applicable. If not applicable, then we'll have to distinguish it. But all these things are not possible now in view of a review filed by you against the said order which came to be dismissed, to be followed by an order filed, appeal filed by you, which is pending. Where is the scope to interpret this order now? During the pendency of the writ appeal. That is your ground of appeal, isn't it? Your ground of appeal is that this order is not applicable.
and also, my lord,
Your Lordship may fix it immediately after 26th, Your Lordship.
It is submitted at the bar that issues raised in the writ petition came to be considered by a coordinate bench. If you have the orders, date of the orders.
My lord.
It is so-and-so, Justice Surana's order, whereby the writ petition was dismissed against the said order, and the review petition was filed, which also came to be dismissed. And presently, a writ appeal has been filed, which it is submitted at the bar that the same is pending after condonation of delay. Since the question of since the order dated so and so passed by the coordinate bench may have a bearing in the present proceedings, this court is of the view that the matter should be deferred to be listed again in the month of March,
First week of March, Your Lordship.
first week of March. March or at the good. Person.
It is 22/9/2025.
Justice
Review.
Surana's order,
Yes,
22/9/25.
2025.
it was review, my lord. It was review, the petition was 12/6/2020,
12/6/25.
24.
24 was the original writ petition.
Yeah.
In WBC number
WBC number 3015
3015 of
and
20
others also, my lord.
of 24.
24.
24. Another connected writ petition which came to be, which was sought to be reviewed, came to be dismissed by the subsequent order.
My lord, 22/9/2025 in review petition number 139 of 24.
22/9/25 in review petitions of such.
139/20.
Yes.
Deeply obliged.
We release it from Part Heard then.
Let it be your lordship. I mean,
Let it remain, my lord, or my lord.
Next,
There's.
next date, your lordship.
All right, fifth,
Lord.
5th of March.
Obliged.
5th of March is the hearing day. Hearing day. March or calendar. Yes.
In fact, I wanted to file and reply to the affidavit, Lordship. Lordship, may kindly see one, only one thing I will.
What is your challenge here?
Lordship, Lordship, we are challenging the bunching of SOCO's notice. The SOCO's notice which has been
What
sent.
is illegal about it?
Huh?
What is illegal about it?
Yes, your Lordship. Lordship, the illegality.
And I was
Lordship-
informed that Delhi High Court's order has been upheld by the Supreme Court.
No, your Lordship.
Yes,
No, your Lordship. Even the Supreme Court, several other cases are already pending. Lordship, I'll place before your Lordship. I have I'm submitting a compilation, Lordship, in respect of this.
What compilation?
Lordship, all the judgments of the various high courts as well as Delhi High Court and the Supreme Court's order, Lordship, everything.
Supreme Court order is?
Lordship, this Lordship, what they have, this Lakshmi Mobile Lordship, this is still pending.
Maybe, but
Lordship, in the case of Mathur Polymers, the Supreme Court has dismissed the SLP, Lordship.
Lordship, may kindly,
Edits, Lordship.
hmm,
This order was passed by the Honorable Delhi High Court, which has been subsequently upheld by the Supreme
Lordship, I
Court.
don't have the copy of the Mathur, that
They
is
recent
why I wanted,
Lordship.
Lordship, that is why I wanted to bring everything on record, Lordship.
Hmm.
Lordship, may kindly peruse the, Lordship, in the compilation, Lordship, the Apex Court judgment in Ambika Traders, Lordship, may kindly see the page number 218, Lordship.
hmm. No, is there a bar under the statute?
Yes,
You
Lord.
cannot issue
Yes, sir. Yes,
consolidated
this is what I
show
wanted, this is what I want to place, Lordship. There is a bar in the statute, Lordship. Because, Lordship, Lordship, if the Lordship, the various provisions of the act are, Lordship, read,
Hmm.
Lordship, it will give that it has to be passed per financial year.
Now, How are
The
you,
purpose notice has to be given per
how are
financial
you,
year.
how are you prejudiced?
Lordship,
How
why?
are you prejudiced by issuance of a notice?
Lordship, because
collective-
I am unable to, Lordship, reply to a per assessment year, Lordship, because thing is that per assessment year is a different proceedings, Lordship, as your Lordship know that
The
BSNL,
different
Lordship,
proceedings, you seek
it's
the,
separate. It's a, Lordship, every assessment year is different, Lordship.
where are the show causes? Let us see.
Lordship, Lordship, I have not, this is my primary ground, Lordship. I am challenging on the so-called notice on various other grounds also.
All right, but
Lordship,
where are the
Lordship,
show cause notices?
this Lordship, Shoko's notice is at page 109.
109. Yes. Demand comes so cause notice, 25, 26.
Lordship, this is 2018, 19, 19, 20 and 2021. 3 years taken together.
Where do you find it?
Lordship, the first page itself.
First page itself. 18, 19, 19, 20, 2020.
2021 to
Hmm.
November. Lordship, in this case, Lordship, what has happened that all these 3 years have been tagged together, and the Lordship, what they have done is that they have also tagged together 3 persons. They cannot issue tag 3 persons together for a single notice. Lordship, they have issued a notice on the company differently, levied tax and interest and penalty on them. Then, Lordship, on the director also. Director, Lordship, they have levied penalty also on them. At that point of time, Lordship, the provision was also not there to levy penalty. Separately, Lordship, equivalent penalty has been levied on the director. Then, Lordship, to the clerk and accountant. 3 persons have been tagged together
Of
and
this,
the years.
of your company,
Yes, your Lordship.
they are officers of your company.
Lordship, my director is from the company, and Lordship, the clerk who is there, they have issued the notice, Lordship, the penalty notice to the clerk also. Lordship, they are, and the allegations are different. Against all of them, allegations are different. Because Lordship may kindly see, Lordship, at page, if your Lordship will come to page, Lordship, 141. Page 141, Lordship, paragraph 17, demand and recovery. Now therefore, notice number 1, Gupta Hardware Private Limited being GST and so and so having principal place. Lordship, this is against the company. This is the notice number 1. And Lordship, it has been said that tax amount of rupees so and so. It is a big figure, Lordship. Even if I want to file an appeal against, finally, if an Lordship, the order is passed, if I want to file an appeal, I have to deposit a very huge amount. Maybe some amount, for some of the year, I want to pay the amount and finish it off, because for 2018-19, the amount is very less. I want to finish at the piece of the amount and pay that amount and finish off, but I cannot, because they are Lordship bunching it all together. So what is the Lordship, what is the problem if they can issue for different assessment years separately? This is what has been held by the other high courts. The other high courts have not set aside the entire so-called notice per se. They have also given them this thing that they can issue a separate notice now. Lordship, this amount, the amount of rupees so and so should not be demanded and recovered from them under provision of section 74 of the GST Act with identical provision under the Assam tax. Interest on the tax amount should not be demanded. Then thereafter penalty equivalent to tax amount. So Lordship, penalty equivalent to tax have already been demanded from the company. Again, Lordship, Lordship 17.2, Lordship will see. Now therefore notice number 2, Sri Rajesh Kumar Gupta, Director of Mrs. Gupta Hardware, is called upon to show cause before Additional Commissioner of so and so, having office at so and so, penalty equivalent to tax amount. So Lordship, the company will have to pay the penalty equivalent to tax amount. Now this Lordship, director will have to also pay penalty equivalent to tax amount evaded by so and so by way of clandestine supply without issuance of proper invoice should not be imposed on them under section 122(1)(a) of the CGST Act. Now Lordship, this 122(1)(a) of the CGST Act was inserted, Lordship, into the provisions of the Lordship 122(a) GST Act, Lordship, recently. And it does not apply to those assessment years, 18, 19, 19, 20, 21. So Lordship, giving a notice to, now I cannot, Lordship, if I want to fight against this notice, I have to fight along with this company. Why should I fight along with this company? Because I have to personally pay this amount to the Lordship, this one. Lordship, this 122(a) was not there in the book. This has come into effect with effect from 15 to 2024. Now my assessment years involved are 18, 19, 19, 20 and 2021. So when my assessment years are 18, 19, 19, 20, 2021, 122(a) will not be applicable because 122(a) had come into the books only on Lordship 110, with effect from 110, 2024. So if it has come into the books with effect from 110, 2024, my notice number 2, Lordship, the penalty which has been levied cannot be levied on me. But Lordship, how will I reply to this notice? Because I have been tagged along with this company. Now, Lordship, there is notice number 3. That is Ravi Sharma, accountant of so-and-so, so-and-so. Penalty for aiding and abetting the so-and-so. He has been also levied the penalty under section 122(1)(1)(1)(15). So Lordship, this is somewhere they say that he is a clerk, somewhere he says that he is an accountant. He also want to fight against the penalty which has been levied against him. How will he fight, Lordship? Lordship, all these notices have been tagged together in the single notice. So Lordship, this notice appears to be, Lordship, a bundled notice, and Lordship has been, everybody is aggrieved, but for different points. I cannot fight, Lordship, the other notices cannot fight the case.
Why?
Because they have to, if they have to fight the case along with the company. Company is a different case, Lordship, regarding tax if that has been evaded. And Lordship, the other notices have a different case
Other
altogether.
notices are employees of the company only.
Lordship, the director is not, even though he is not an employee of the company, but against him the charges are different than the company.
Maybe.
The charges are completely
Where is the
different.
bar? I don't understand. I am
Lordship, I
trying
will
to
show the bar.
understand.
Lordship, that is why I wanted to file the reply. Lordship, I'll show the
What
bar.
is there to file a reply? You point out from, see, this Delhi High Court had relied on a division bench judgment of the Delhi High Court
Yes,
on the
that is
ground
true.
to say that
That is true.
this is permissible. There is no bar.
Lordship,
Which case SLB case
relying
dismissed.
Delhi High Court judgment, Lordship, the
Hmm.
Bombay High Court as well as the Karnataka High Court, that Lordship, that order I have placed before in the bunch, Lordship may kindly see, relying on the judgment of the Delhi High Court, Bombay High Court and the Kerala High Court has passed the judgment, and the Kerala High Court is before the Supreme Court. The matter is pending before the Supreme Court. Lordship, may kindly see the judgment of the Bombay High Court, which I have given in my compilation from page 1 to 28. Lordship may kindly see that this Ambika Traders and the Supreme Court order of Ambika Traders has been considered by this Lordship, by the judgment of the Bombay High Court. Lordship will see at page 11 of my compilation, 10 in 11. Lordship, the decision of Delhi High Court in the case of Ambika Traders through proprietor so-and-so, dated so-and-so, in writ petition, which has been also been challenged before the Supreme Court, Apex Court. Lordship, that fact has been considered, and thereafter, Lordship, after considering this, the
What
court,
orders have been passed by the Apex Court?
Lordship, the Apex Court, the matter was withdrawn by Ambika Traders. Lordship, I have placed, Lordship, Lordship may kindly see
Why are
the,
you referring to it?
Lordship, page 218, page 218, Lordship.
No, no, you are pointing out to 10, 11, something like that.
Lordship, this was Bombay High Court judgment,
Hmm.
but Lordship, the Delhi High Court judgment, Lordship, the Delhi Court, the judgment which has been passed. Against that, Lordship, the SLP was preferred, that was withdrawn by the petitioner. Yes, Your Lordship. The withdrawal order has been, Lordship, I have annexed with the.
We don't want the withdrawal order. We
Yes,
want to know if there's any interference by the Apex Court. Then the SLP has been withdrawn. There is no scope for interference in that matter. At
Lordship,
least.
that matter.
Ah,
Lordship,
so that division bench judgment of the Delhi High Court has attained finality and which has been relied upon by subsequent.
but Lordship, that because see, it has been withdrawn, the Lordship issue is still open.
Issue
be
is
decided.
open to be decided until
Yes,
it
Your
is
Lordship.
decided. As on date, there is no decision.
Lordship, in this High Court may decide the issue. Lordship,
can
I'll place
decide.
all the provisions of the act to
You tell us what is wrong with the ratio of the Delhi High Court judge.
Lordship,
What is so atrocious that
Lordship, the Delhi High Court has not
a similar order?
the Delhi, Lordship, there are two reasons that I am saying that Delhi High Court is wrong, is not applicable in my case. Firstly, Lordship, the Delhi High Court has not dealt with the provisions of the GST Act. It has gone into the,
What is
other
the provision, where, which provision,
Lordship, GST Act, Lordship, various provisions of GST Act.
no,
Lordship.
which provision expressly
Hmm.
says that you cannot be issued consolidated show cause notice?
Lordship, for that, Lordship, you have to hear me, Lordship.
We are hearing you only.
Yes, Your Lordship. Lordship, it is not a one-line answer, Lordship. I'll show with the various provisions that which shows that which will come to a conclusion that yes, it cannot be passed, Lordship, for a single for a bunch of years, Lordship. Lordship, I'll finish my argument. The second reason which I am challenging the Ambika.
You will finish your arguments, we understand, but point out from some statutory rules,
I'm going to.
circulars.
Yes, Your Lordship. I'll place all the sections, Lordship, from of the GST Act.
All the sections are not necessary. Why should we
Lordship, the
go through
relevant
all the
section.
section?
Relevant section, three
What-
sections.
what
If I'll
section?
place three sections, I will place, Lordship, that will make the things
Yeah.
clear.
Which
Lordship,
section?
before that, Lordship, I'll say that Ambika Traders was because that person was fraud, Lordship. That was relating to some other things. It has gone to, that is what the Bombay High Court has held, that was because of some other issues. That the matter was decided, not because of the thing. Lordship may kindly see, Lordship, section 2, subsection 97 of GST Act, Lordship.
Yes.
Lordship, section 2, subsection 97 refers to return.
Mm.
Return means any return prescribed or otherwise required to be furnished or under this act or the rules made thereunder.
Mm.
This is very important, Lordship. Along with this, Lordship will read, Lordship, section 2, subsection 106,
Mm.
tax period. Lordship, tax period means the period for which the return is required to be furnished.
Mm.
So, Lordship, return and the tax period is the for which the return. So that is why this both the tax period can be only in respect of means the period for which the return has to be required to be furnished. So it has to be read along with the return. So what? So, Lordship, now we have to see key return.
Mm.
What are the returns which are allowed to be filed? Whether we are allowed to file 4, 5, 6 years return together so that it can be considered to be tax period. Because tax period can be considered only for the period for which the return is required to be furnished. Lordship may kindly now see what is the return, Lordship. Lordship may kindly see section 39. Of the GST Act, Lordship.
Mm.
There are furnishing of returns, Lordship.
Yes.
So, Lordship, how the returns are going to be furnished under the GST Act? It is said that every registered person other than so-and-so or a person paying tax under provisions of section 10 for every calendar month or part thereof furnish a return electronically of inward and outward supply of goods or both input as in such form and manner and within such time as may be prescribed. So Lordship, this is written that for every calendar month.
Hmm.
So this is one of the return which has to be filed, which is every calendar month.
Hmm.
Then thereafter, may kindly see the provision subsection 2, Lordship. A registered person paying tax under provisions of section 10 shall for each financial year
Hmm.
or part thereof furnish a return electronically of turnover in the state or union territory inward supplies of goods, tax payable, and such particulars are in form and manner and within such time as may be prescribed. So Lordship, again, there is a prescription for filing monthly, there is prescription to file of Lordship annual return.
Hmm.
So Lordship, annual return has to be filed. Lordship, then Lordship, every registered person required to deduct tax at source shall electronic furnish a result for every calendar month of the deduction made during the month in such form and within such time as may be prescribed. And Lordship, provided the said result shall furnish a return for every calendar month, whether or not deduction have been made during that said month. So Lordship, this is monthly return and this is annual return which has been required to be furnished even either of the Lordship, whatever supply I have made or any deductions that I have made. Only monthly and annual return. Lordship, another return which I have to file is at section 44. Lordship, before that, Lordship, the 39, Lordship, 8 also, Lordship. 39.8. Every registered person who is required to furnish a return under subsection 1 or subsection 2 shall furnish a return for every tax period, whether or not supply of goods of both have been made during such tax period. This is what is Lordship. Lordship, thereafter, Lordship, may kindly skip and come to section 44, Lordship. This is the second return which we need to file, that is annual return. Section 44. Every registered person other than an input service distributor, a person paying tax under so-and-so, a casual taxable person and a non-resident taxable person shall furnish an annual return, which may include a self-certified reconciliation statement reconciling the value of supplies declared in the return furnished for the year. So Lordship, this is the annual return also that we have to file apart from the monthly return and the financial year return, which was prescribed, Lordship.
Hmm.
So these are the two returns which has been prescribed under the Act.
Hmm.
One is Lordship monthly, the other is Lordship annual return. So Lordship, tax period refers to the return, Lordship. So Lordship, that is why Lordship may kindly thereafter come to Lordship Rule 62.
Where is that notice?
Hmm?
Which provision provides for notice?
Lordship, thereafter, last Lordship Rule 62 I will place, thereafter section 73, direct.
Hmm. Now,
Rule 62, Lordship.
62.
Lordship, I'm just referring to the various provisions of the law.
Yes.
This is the prescription, Lordship, because some people are allowed to file quarterly also, not just monthly. Under the rules, Lordship, may kindly see Rule 62. May I read your Lordship?
Hmm.
Every registered person paying tax under section 10 shall furnish a statement every quarter or as the case may be part thereof containing the details of payment of self-assessed tax in form so-and-so till the 18th of the month succeeding such quarter, and furnish and return for every financial year or as the case may be part thereof in form GSTR 4 till the 30th of April following the end of such financial year electronically through the common portal either directly or to a facilitation center provided by the commissioner. Provided that the return for a financial year from 24-25 onwards shall be required to be furnished by the registered person till the 30th day of June of such financial year. So Lordship, this 62, Rule 62 also talks about quarterly return also. If somebody is not able to file monthly, he can file quarterly return also. Lordship, thereafter, Lordship 62, subclause 4 of Rule 62. A registered person who has opted to pay tax under so-and-so section 10 from the beginning of a financial year shall where required furnish the details of outward and inward supplies and returns under rules 59, 60 and 61 relating to the period during which the person was liable to furnish such details and returns till the due date of furnishing the return for the month of September of the succeeding financial year or furnishing of annual return of the preceding financial year, whichever is later. For the purpose of this sub-rule, it is declared the person shall not be eligible to avail ITC on receipt of invoices or debits from note from the supplier for the period prior to his opting for the composition scheme. Lordship, here I will Lordship pause for a little. Lordship, even Lordship, if I am Lordship allowed to take input tax credit also.
All right, then what?
Lordship, if if I may permitted to Lordship one more section of section 16(4). Thereafter, Lordship, I'll come to section 73. 16(4). Section 16 is relating to input tax credit.
Yes,
Input tax credit, eligibility and condition for taking input tax credit.
section
16, Lordship.
16.
16, Lordship, 16. Because Lordship, in the act, everywhere it is mentioned about financial year.
No, but the question is, how are you prejudiced?
Yes, Your Lordship, that also I will place. Lordship.
Oh,
Section 16, every registered person shall subject to the condition and restrictions as may be prescribed and in the manner specified in section 49, entitled to take credit of input tax charged on any supply of goods or services or both to him, which are used or intended to be used in the course or furtherance of his business, and the said amount shall be credited to the electronic credit ledger of such person. Lordship, I am allowed to take input tax credit. Now, for every supply I am making, or if I am taking Lordship from somebody, and I'm supplying to somebody else, so whatever tax I have paid to the seller of the goods, whatever tax I have paid, I am entitled to take credit of that sale, which is in the name of input tax credit. Now, how can I take the input tax credit? What are the factors, Lordship? Lordship, may kindly see subclause 4, which is very important in this. Subclause 4. A registered person shall not be entitled to take input tax credit in respect of invoice or debit note for supply of goods or services or both after the so-and-so following the end of financial year to which such invoice or debit note pertains on furnish of the relevant annual return which is earlier. So Lordship, my input tax credit is also dependent on the financial year. Otherwise, I will not get. So Lordship, that entire GST is Lordship based on Lordship section 16 is the most important Lordship part of GST, that I am getting input tax credit at every step. So that is also relating to the financial year. So every financial year is very important, Lordship, because all the financial years are not mixed together in this entire act. All financial years are different, and input tax credit I will get for every financial year differently. I'm not permitted to go beyond that financial year. Otherwise, I will Lordship lose the input tax credit.
all right.
Lordship, thereafter, Lordship may
We'll
kindly.
come back. We'll come back. There are other matters which are fixed on some date.
Yes, Your Lord.
Which date is it?
Lordship,
The date is not fixed.
one is fixed on 24th of February. By part of the
24th.
I think so, Lordship, that interim. Lordship, I have given it in the compilation board. Yeah, no?
Is it this page 219?
I have, yes, Your Lordship. Quantum
This is fixed on 6/2.
6-2.
All right. We will continue on 6/2.
Lordship, may kindly keep it part.
Yes, third in part.